Welcome to the free legal advice show on British Muslim TV. I'm your host, Ilyas Bulbulia, and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On this show, I should be able to cover a vast, diverse range of matters. Matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your questions are, as long as they relate to English law and the English legal system, please feel free to ring on the numbers that appear at the bottom of the screen. The number that you can call on if you want to speak to me live on air is the landline number 01924 231 083. Alternatively, you can send me a message on WhatsApp or by text message. And the number that you can do that on is the mobile number which appears at the bottom of the screen. So a live call to the studio here, please call on the landline number, and to send me a message with your query, please do send it on the mobile number. Every week we get numerous messages on WhatsApp. It's a fantastic way for you, our viewers, to get in touch. And I appreciate that many of your questions, when they relate to English law, when they relate to, for example, immigration law matters, may be quite confidential. You don't necessarily want to discuss those matters live on air. So a fantastic, easy way for us to deal with those questions is for you to simply send the questions in on WhatsApp. A couple of very minor matters before we get going. Obviously, on a live show, it's difficult to take very detailed information from viewers who call in. Now, if it transpires that your matter is quite complex, then I will give you some initial advice live on air. But if it's a complex matter, I'll ask you to leave your number with the control room, and I will then speak to you off air, take more detailed information from you. And again, if it's a complicated matter, what I would advise is that if you have a lawyer who's already advising you on the matter, please do take a second opinion from them as well. Secondly, sometimes I do need to look at documents before I can advise properly. This seems to happen more often with immigration law matters, where somebody might have received a refusal for a visa application that they've submitted. And if that's the case, again, I'll ask you to leave your number with the control room, and I will then arrange for you to send your document to me on WhatsApp or by email. I'll have a look at the documents, and then I will have a more thorough discussion with you. So if it's a complex matter, I need to see your documents. That's no problem at all. By all means, do get in touch, and we'll arrange for that more thorough discussion to take place, or for you to send your documents in. And as always, this is a free legal advice show. Even if you need to speak to me after the show when you've sent more documents in, that is part of the free legal advice show. There's no charge at all for that. So by all means, do please get in touch on the landline number or the mobile number. Now, as always, we've had a number of questions that are coming in on WhatsApp already, which is fantastic. Let's look at one of the questions that's already come in, but by all means, do continue, please, to send your questions in as always. Now, the question that's been sent in is this, and our viewer says, "Assalamu alaikum, my question is, I am settled in the United Kingdom as a member of an EEA national." So the person's a family member of an EEA national. "My child was born in the UK when I had pre-settled status. However, I now have indefinite leave to remain. I wish to apply for my child to become British. What application form do I need to file?" Okay, so reasonably straightforward matter. Our viewer is saying that they were a family member of a European national, and on that basis, they had pre-settled status. So they didn't have indefinite leave to remain in the United Kingdom, they had pre-settled status. Similar to having limited leave to remain in the United Kingdom. And it's at that time that the child from the relationship is born. Now our viewer is saying that our viewer now has indefinite leave to remain. So under European law, it would be the case that they've got settled status, similar to having indefinite leave to remain. Now that they have indefinite leave to remain, they want to look at the child's position. How does the child become British? So that's basically what our viewer is asking on WhatsApp. Now, the position really is this. In terms of children who are born in the United Kingdom, certain children are automatically British, and there's nothing that needs to be done. They are eligible for a British passport, and they would simply make an application for a British passport in the normal way. So who is automatically British when they're born in the United Kingdom? Well, to determine what the answer to that is, it's really a question of what the parent's status is. So just by being born in the United Kingdom doesn't mean anymore that you are automatically British. So birth, unlike some other countries, birth in the United Kingdom doesn't confer British nationality automatically. What you do look at is your parents' immigration status. What your parents need for you to have indefinite leave to remain, generally speaking, is that your parents need to be British citizens, or they must have indefinite leave to remain at the time that the child is born. Now, here, the scenario is slightly different because the child is born when one of the parents has pre-settled status, doesn't have indefinite leave to remain. So nationality, automatic nationality, isn't something that the child gets by being born in the UK because the parent didn't have indefinite leave to remain. So here, what we would need to look at is the status of the other parent. Assuming the other parent also had pre-settled status, not indefinite leave to remain, the child would not be British. So in order for the child to be British, the parents need to be either British citizens or they must have indefinite leave to remain. Now, it doesn't matter if the parent who's British is out of the country at the time of birth. That doesn't matter. It's the status of the parent which matters. If the parent is British or has indefinite leave to remain, the child who is born in the UK is automatically British. Now, what happens where the parents weren't British or didn't have indefinite leave to remain at the time of the child's birth, but later on acquired indefinite leave to remain? Well, in that case, it is possible for the child to apply for British nationality. So the child's not automatically British. The child has to apply for British nationality. And that's done by an application for registration as British being made on behalf of the child. And the form that needs to be completed is a form called Form MN1. So it's a nationality form for minors. I think it stands for minors nationality form 1. So that's the form that needs to be completed. And the process that you go through results in the child being registered as British. Once that's done, it's then possible to make an application for a British passport for the child. So it's a two-step process. First of all, because the parents want indefinite leave holders or British at the time of the child's birth, the child needs to be registered as British first, and then an application for a British passport in the normal way would have to be made. Hope that answers that question. As always, if you want to speak to us live on air, you can call on the landline number that appears at the bottom of the screen, 01924 231083. But by all means, if you want to send a WhatsApp message, please do so on the mobile number that's there. Let's look at the next question that's come in. Our viewer says, hello, I am self-employed as a taxi driver and just got married a couple of weeks ago in Pakistan. I am a British national. I have paid my taxes for 2019 to 2020. However, due to COVID, I haven't been able to work and I'm getting universal credit. Can I still apply for my wife's spouse visa? Now, this is an issue which is arising quite frequently now, especially for those who are self-employed, especially for those who are taxi drivers like our viewer who has texted in. So 2019, 2020, everything was up to date. The income's there. I'm assuming, and we don't know what the position is, I'm assuming the financial requirement was met at that stage in 19 to 20, the 18,600 requirement. Now, the difficulty that we now have is this, that because we've now entered the new financial year, the documentary evidence which needs to be submitted in terms of finances is the financial documents for 2020 to 2021. So the old accounts, the old tax return for 1920, they're out of date now. So when you make the application, what the Home Office will look at is your income for 2020 to 2021, April 20 to April 2021. And it's in that year that your income needs to be sufficient. Now, I accept what you're saying, that you're now in receipt of universal credit. However, there may be a possibility of making an application based on 2020, 2021 earnings. Now, it's possible, and you haven't said here, that your income dropped in 2020, 2021. The Home Office has said that it will accept reduced income where somebody's income has dropped due to COVID-19 and the lockdown that we had. So you could still potentially apply. However, my view is you would still have to be self-employed even though you're not earning sufficient money. So you might be getting universal credit, but you still need to be registered as self-employed. Now, this is quite a complex matter. So what I'm going to do to answer your question as fully as possible and to get you in a position where you can potentially apply is to look at this in greater detail after we come back from our short break. So we'll look at this after we come back. We'll be back in the next couple of minutes. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please do call on the landline number that appears at the bottom of the screen. And as always, if you want to send a WhatsApp message with your query, please do so on the mobile number that appears at the bottom of the screen. We have a number of WhatsApp messages coming in, which is fantastic. Just before we took the break, we were looking at a query that our viewer had sent in regarding applying for a spouse application for our viewer's wife who's in Pakistan. And the particular issue that was being raised was in relation to self-employed income. What our viewer said was that in 2019, 2020, so that's April 19, April 20, he was working, earning enough money, currently is on universal credit. So can a spouse application be met? And in more particularly, as far as this query is concerned, can the financial requirement be met in these circumstances? And just before the break, I was explaining that the Home Office has introduced some, I do apologise, has introduced some flexibility in terms of income, self-employment income, which has dropped due to COVID-19 and the lockdown that we've had here. What the Home Office position is this, that, and the problem is the guidance which deals with this is very, very brief. So what the guidance, brief as it is, says is this, that if in the last financial year, so we're talking about April 2020 to April 2021, the financial year that's just passed, if your income's dropped due to COVID-19, then we will accept your reduced income. So what I was trying to explain to our viewer was, if you had sufficient income in 2019 and 20, let's say you met the financial requirement then, you were earning £19,000, £20,000, whatever it is. And in the immediately previous financial year, 2020 to 2021, your income's dropped. The Home Office will accept your reduced income. So let's say your profits are £10,000, £11,000. The guidance says that the Home Office will accept that reduced income. However, my view is this, that you still need to be self-employed at this stage. Even though your income may be such that it's reduced to the extent that you now qualify for universal credit, you still need to be self-employed. So if you are self-employed, you can rely on your April 2020 to April 2021 earnings, even though they don't meet the £18,600 requirement. So you'd still need to submit all the required documents for April 20 to April 21. So the accounts prepared by your accountant, you'd need to submit, your tax return for April 20, April 21, your SA 302, which is generated after your tax returns are submitted, and your SA 300 or your statement of liability, statement of account, which shows the running balance of how much tax was payable, how much you've paid, what's outstanding. So the documentary evidence that has to be submitted, that's not changed. You still have to submit the same documents, but obviously those documents will show a reduced level of income. Now, the revised guidance on this, the flexibility that's been introduced by the Home Office, doesn't deal specifically with this point. It doesn't say submit your previous years, as in 2019 and 20 accounts, but I would submit that as well. And the reason for submitting that would be this. It's to show the Home Office that, look, up until April 2020, when there was no problem, or the problems really hadn't started with COVID-19 here, we didn't really have a lockdown until around that time. It's to show that my income was such that I met the financial requirement then. So the Home Office can look at your old income and look at your COVID-affected income and see that this is a person who met the financial requirement before. And it's only now, in the last financial year, because of what we've had, what you've had to endure, that you don't meet the financial requirement now. So that's the way I would do it. But the caveat here is this, and it's not clear from the question that you've sent in. My view is that you should still be self-employed now. It doesn't matter that you qualify for universal credit because your income is so low, but you should still be self-employed now. So assuming you tick those boxes, my view is that you should proceed with submitting your wife's spouse application with those supporting documents that I've mentioned. Hope that answers your question in depth. Right. Okay, let's take the next caller who's online. Hello, Assalamu alaikum.
Assalamu alaikum wa rahmatullah.
Wa alaikum assalam, brother. Thank you for calling. What's your question?
Yeah, thank you for taking my call. Jazakallah khairan. Ramadan.
My pleasure.
Brother, just my question is, my sister lives, she's not a resident in this country. Basically, she lives abroad, back home in Iraq. And she's interested, I'm interested in buying properties in her name, her money, basically. And just wanted to know, I do have a full power of attorney. And in the case of, buying, and if we had to sell, what are the possibilities of that? What taxes is there to, implement on this?
Okay. There's a couple of issues here. The first of all, in terms of holding the power of attorney, the first issue, practical issue, is this, that you need to find a solicitor who's willing to deal with this, where you've got a power of attorney on behalf of your sister. The solicitors need to be satisfied that you are acting on behalf of your sister. So find a solicitor that you know. They might want to speak to your sister directly, etc. But assuming you can find a solicitor who's willing to deal with you when you hold a power of attorney, it's absolutely fine. You can deal with buying and selling property through your solicitor with that power of attorney. Now, taxes, brother, is obviously a separate issue. Now, on the Inland Revenue website, there is guidance on how So with property, two things normally arises. One is rental income, which comes in. So there's an issue about income tax when the rental income comes in. Somebody who's abroad, would they be taxed or not? So that's the first issue that arises. The second issue that arises is when the property is sold and a profit is made, there's an issue about capital gains tax, whether any capital gains tax is payable or not. So there's two issues with property: the rental income, which may be subject to tax, and the capital gains tax upon a sale. Now, generally speaking, when you don't live in the United Kingdom, there wouldn't be any taxes payable. But what I would suggest you do, because I'm not an expert in this area, is that HMRC, if you go onto their website, and I've done this before, is that they've got a dedicated number for tax issues where the person who holds the property is abroad. So it might be worth just speaking to them to get an opinion. But from my understanding, because your sister would be abroad, first of all, if she had income, rental income of, let's say, 10,000, 11,000 pounds a year, that's within her personal allowance anyway, so it's not taxable. Secondly, because she's abroad, it's unlikely to be taxable. Upon the issue about capital gains arising, my understanding is because she's abroad, she wouldn't be subject to UK tax. But I'm not an expert in this area. What I would do is go onto the HMRC website and have a look. On the rental income, I think there's no issue. And the capital gains tax, do check on the HMRC website. I don't want to give you a definitive answer. It's not my area of expertise. What I can do is have a look at it, speak to my property lawyers who work with me, and I can give an answer next week on the show. So if you are watching, I can give an answer then.
I'm watching all the time, and it's a win-win situation. Subhanallah. Jazakallah khair. I'm so pleased to hear that from your good self.
Jazakallah,
I'll
brother.
be looking forward to hear maybe more next week, inshallah.
Inshallah, brother. I will speak to my property lawyers and I will give you a definitive answer next week.
Thank you.
On Tuesday, brother.
Thank you.
Jazakallah. Thank you very much for your call. Thank you.
Allah.
Thank you very much. Allah Hafiz. Allah Hafiz. And obviously that's to do with an issue relating to capital gains tax, where somebody who's abroad. I think there is an easy answer to that, but instead of taking a guess, I think as I said to our caller, inshallah, I'll have a discussion with my property lawyers and then answer that question next week. Okay, just before we took the call, we were looking at reduced income that a sponsor in the UK may have, and the difficulty that the sponsor may face when the sponsor is trying to sponsor a husband or wife to come to the United Kingdom. So we looked at the problem with self-employed income dropping. Now, one of the other questions that's come in is looking at whether there's any further flexibility or whether there's any similar flexibility for somebody who is employed and suffered a loss of income. This is quite a topical question. This is an issue which is arising quite frequently. And in practice, we're having to work out solutions for clients who previously had good income. They were earning 20, 25, 30,000 pounds a year. And because of the kind of year that we've had, either they've lost their job or their income has dropped. And so we're trying to look at solutions. Now, what the Home Office has done is actually introduce some flexibility. So there is flexibility around showing your income before the income dropped due to COVID. So there's some rules relating to that, which I'll look at in greater detail. There's some rules relating to you being able to rely on your furloughed income. So 80% of your income, and that would be counted as 100% of your income. So the Home Office has done a couple of things in order to make it easier for sponsors to sponsor their partners from abroad to the United Kingdom. So there is some help. And what I will do after we come back from our break is to look at that in greater detail. We've already discussed what the position with self-employed income is. There is some flexibility. It's not brilliant. And I have to say, in practice, some people do manage to rely on that and get through. For others, we've had to say, look, you know what? it's too difficult to try and get this application through. What you do need to do is wait until you get stable employment, until you start earning a proper income which is sufficient to meet the financial requirement. So in some cases, that's the advice. What I will do after the break is to look at the Home Office flexibility in terms of reduced income. We'll be back in the next couple of minutes. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, you can ring please on the landline number 01924 231 083 or to send me a WhatsApp message which will be sent through to me here in the studio. You can do that by sending a message on the mobile number that appears at the bottom of the screen. So either is absolutely fine. Please feel free to give me a ring live on air or to send me a message. Now, just before we took our break, we were looking at the flexibilities that the Home Office has introduced in relation to somebody who's applying for a spouse application and the sponsor's income isn't sufficient. And I touched upon two issues. One is if your income has dropped, the Home Office is prepared to look at your income immediately before your income dropped due to COVID. So it may be that your income was as normal. To give you an example, let's say your income in January 20 to June 20 was as normal. You were earning £18,600 a year. So that would be enough to meet the financial requirement. So you're earning that level of money. And unfortunately, in the second part of 2020, your income's dropped because of COVID. So what the Home Office has said is they are prepared to accept your pre-COVID income. So you'd put your wage slips in for that period and you would get an employment letter. And the employment letter would explain that, this is what's happened. This was the normal income that this person was receiving. However, due to the impact of COVID-19 on our business, we've had to reduce hours or reduce pay in certain circumstances or demote people, etc., change jobs. And that's what's resulted in this person receiving less money now. Now, that is acceptable to the Home Office. So that's helpful for some applicants who've suffered a reduction in income. Now, the second bit of good news is that, and this will apply to a lot of people, is where our sponsors here in the UK wanting to sponsor a husband and wife to come over to the UK, still employed, still earning money, but the income has been reduced because they've been placed on furlough. So they're not going into work. Instead of getting 100% of their pay, they are now getting 80% of their pay. So for example, somebody who was used to getting £2,000 gross per month, that's 100% of their wage, they are now receiving 80% of that, which would be in the region of about £1,600 per month or thereabouts. What the Home Office has said is, in the situation where, because you've now been furloughed, you're not receiving 100% of your pay, you're receiving 80% of your pay, we will count your 80% of pay as if it's 100%. So that £1,600 will be counted as £2,000 a month. So that's very helpful as well. So there is some flexibility there in terms of sponsoring a husband or wife to come to the United Kingdom, whether you're self-employed or whether you're employed. Hope that answers your question. Next question that's come in relates to English certificate, and our viewer says that we are ready to make an application for my wife's spouse visa. However, my wife is unable to do the English test in Pakistan because she's unable to book a test in Pakistan with the current situation there. Is there any flexibility as far as that is concerned? Look, the position is this, and this is the same position with the TB test and the English test, where it is impossible to do a test because test centres have closed. And this is more relevant to English tests. And the Home Office has specific guidance on this, that where it is not possible to do the test because the test centre has been closed, then the Home Office is prepared to accept, as long as you're able to submit evidence that the test centre is closed, the Home Office is prepared to accept the application without that test certificate. And likewise, the Home Office has said that if you're making a spouse application and you're not able to, say, for example, submit an employment letter because it's difficult to get the employer to do the employment letter because the employer might be short-staffed, or they may simply be saying that we're not doing anything which is not absolutely urgent or essential at this stage, and because of that you're in difficulty in getting the employment letter, so you're in difficulty making the spouse application, the Home Office has said that's not a problem, you can submit your application without it. So the Home Office is prepared to be flexible. You need to explain if you've been unable to get a particular certificate, a particular letter, or if there's a problem and it's because of the current pandemic and the impact that it's had on the business. In my experience, currently, the Home Office is prepared to be flexible. And you've seen this in other areas as well. For example, there are applicants who've come on spouse visas from abroad, or more particularly, they've come here on a fiancé visa from abroad. So they're here on a 6-month visa and they want to register their marriage. So they're on a fiancé visa, they want to register their marriage. They're in difficulty in registering the marriage because they're not able to get a date at the registry office. As our viewers who've been through this situation will be aware, you need to give notice to marry, then the actual wedding takes place. That takes a couple of months. There's a huge backlog at the moment. So it's difficult sometimes to get an appointment to give notice to marry. And even if you've managed to do that, it's difficult sometimes to get an appointment for the actual wedding. Now, the Home Office appreciates that if you've been given a 6-month visa and you've not been able to register the marriage as required within those 6 months, then the Home Office says, that's fine. We will simply extend your visa for another 6 months. We'll give you more time to register your marriage. Now, that's very helpful. Unfortunately, if you make an application, there would be a fee to pay, approximately £1,012 for the application. There may be a way around it by emailing the Home Office and asking for an extension by email, but generally speaking, most people submit an application for an additional 6 months to be granted. So the flexibility is there, but it does cost a bit of money to get that extension. So that's something that the Home Office has done. Where documents are missing because of the current pandemic, they're prepared to be flexible. If you're on a fiancé visa and you haven't been able to get married, they're prepared to be flexible. They're prepared to give you more time in order to get married. So there's various things that the Home Office has done. Another concession that the Home Office has made is to say that certain applications can only be made from abroad. For example, if you want to apply as a skilled worker, or if you want to go into the marriage visa category, in certain circumstances, you have to go abroad and make that application from your home country. So, for example, if you're here in the UK as a visitor, you're not able to extend your visa onto a skilled worker visa or go onto the marriage visa if you're here with certain visas such as a visitor visa. What the Home Office has said is it doesn't matter anymore. It doesn't matter what kind of visa status you have. We will allow you to switch into any of these visa categories which you would normally have had to go abroad for. So somebody might be here on a visitor visa, they don't want to go abroad, they can switch into the marriage visa in the United Kingdom. So 1 year into this pandemic, we've certainly seen that the Home Office has been slightly more flexible in terms of dealing with these issues. And where people haven't met the financial requirement when they've applied for indefinite leave to remain or when they've applied for further leave to remain, we've also seen that the Home Office hasn't said, look, you know what, you don't meet the requirements, you've got to go back. The Home Office hasn't taken that approach. They've said, look, you don't qualify, but we'll give you an extension of your visa anyway. So there is a lot of flexibility there. It does make life much easier. Okay, let's look at the next question that's come in. Our viewer asks, and this is relating to marriage, if a person is already married in England and goes abroad and gets married again and has family, can his children be British? So a person is married already in England, goes abroad and gets married. So it must be a second marriage that we're talking about here. Has family abroad. Will the children be British? Potentially the children would be British. The fact that it's a second marriage is irrelevant in terms of whether British nationality passes through the child or not. So it makes no difference whether the child that's born abroad, whether that's a child from the first marriage or the second marriage. So the status of the marriage is irrelevant. So the fact that it's a second marriage is neither here nor there. Potentially the child would be British. What you actually look at is the status of I'm assuming it's the British father who goes abroad and gets married again. So it's the status of the British parent, I should say. What's the status of the British parent? Now, if the British parent is British, then the child would be British in the normal way. Let's take the next caller who's been waiting for a while. Hello, Assalamu alaikum. Hello.
Hello, Assalamu alaikum.
Ji walaikum salam. Ji brother, thank you for calling. What's your question?
Yes, brother. My question is actually the court has given a time to the Home Office for the bundle to be uploaded.
Okay.
Yeah, but they did not upload it, and their time was till 25th of March, but they didn't upload it. So
right. Okay.
They haven't done it. So my question is, does that going to delay the process of my hearing or?
Unfortunately, it will. But brother, what I will do is, I've got the dates down here. We're going to be taking a short break. But what I will do is answer your question in a bit of detail after we've taken the break. I mean, the short answer is there will be a slight delay. But I'll answer that in more detail and what you can do yourself to try and quicken the process. So if after I've given the answer after the break, if you're still not clear, brother, please do call in again. But what I will do is try and deal with this straight after we come back from our break. So we'll be taking a short break. Inshallah, we'll be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please call on the landline number that appears at the bottom of the screen. But by all means, many viewers do send in WhatsApp messages, which is fantastic. Please continue to do that. And the number that you can send a WhatsApp message on is also at the bottom of the screen, the mobile number. Just before we took our break, our brother called in and asked about a matter which is before the Immigration Tribunal, where I think it's an asylum matter, where the Home Office was required to serve a bundle by, I think, towards the end of March 2021, and they failed to do so. And the brother was asking whether that's going to slow matters down. Now, unfortunately, it is going to slow matters down. Because normally what would happen is the Home Office would serve their bundle on you, you would then serve your bundle in response. Now, if your lawyer is of the view that we don't need the Home Office bundle, you can serve your bundle, the appellant's bundle, you can serve your bundle without the Home Office bundle, then do that. If your lawyer takes the view that, you know what, really, we do need to look at the Home Office bundle first to see what they've got, and then we need to do your bundle. Then obviously you need to wait. What you can do in either scenario is basically write to the tribunal and write to the Home Office and say, look, there are directions there. This is what needed to be done. It's not been done. And try and get the tribunal to issue revised directions. Or if you take that step, what could possibly happen is that the Home Office will get a move on, and they'll see that you're being proactive, and the Home Office will take steps to do what's required of them to get their bundle in as well. So, two ways of dealing with this. If your lawyer takes the view that this matter can be progressed from your end without the Home Office bundle, get your bundle in, get your statement in, and tell the tribunal that you've done that. Serve your documents on the Home Office as well. If your lawyer takes the view that no, we need to see what they've got, then obviously before you do anything, then obviously you have no choice here. You're going to have to write to the tribunal. You're going to have to write to the Home Office and push them to do what's required of them, which is to serve the Home Office bundle on you. It will slow matters down a bit, but this is what you can do. So stay on top of it. Get your lawyer to be proactive. I'm sure he is, or he or she is proactive, and get this process moving as much as possible. Hope that answers your question. If you're not clear about anything, by all means, please do give me a ring on the landline number, or send me a message on the mobile number. Okay, we've had a number of other questions coming in on WhatsApp. So let's turn to the next question. And our viewer asks, hi, talking on behalf of my grandmother, she is 75 years old, I have been granted a permanent visa. So I'm assuming it's the grandmother who's been granted the permanent visa in England around 3 to 4 years ago. I've not been granted any benefits or support. My son has passed away, and so has my husband. So grandmother is now on her own. What should I do, as my son supported me financially before? So the key thing here is that grandmother, who's 75 years old, has permanent residence. So she's got permanent residence. So she would now be eligible for benefits that others who live in the UK would be eligible for. So if you have, the problem arises where you've got limited leave to remain. So you don't have indefinite leave to remain. In that situation where you've got limited leave to remain, you may not be eligible for benefits because normally there's a condition on your visa which says you can't have recourse to public funds. I mean, even that can be lifted now in the current climate. But the issue really is here, the issue is slightly different. Grandmother here has permanent status. She has indefinite leave to remain. So there's nothing that should normally prevent you from being eligible for benefits. Now, if you apply for means-tested benefits, let's say it's universal credit or employment support allowance, then your means will be tested, obviously, to see what your income is, what your savings are. And assuming you don't have income, you don't have savings, potentially I can't see why you're not eligible for means-tested benefits. Now, because of your age, if you're unwell, you may also be eligible for disability benefits. And I don't know what your health is like, and hopefully health is well, you're fit and well, hopefully. But if that's not the case, potentially, in addition to the means-tested benefits, universal credit, employment support allowance, potentially you'd be eligible for attendance allowance due to your, if you've got any illnesses. So, on the face of it, you do qualify for benefits. Now, what should you do? Now, if you're finding it difficult to work out which benefits to apply for, the best thing to do is contact the Citizens Advice Bureau. Now, they may not be seeing clients face to face, but they have a website which has a lot of information, and they have a helpline number. They're very helpful. They are experts in the field, in this field, in terms of means-tested benefits, in terms of other benefits. So speak to them. They'll be able to give you a second opinion, but I can't see why there's an issue here. Now, a long time ago, and I've not seen this for a while, a long time ago, elderly parents used to be granted indefinite leave to remain where a sponsorship undertaking was given by the sponsor. And that prevented the person being sponsored, the elderly parent, from accessing benefits for 5 years. But that doesn't apply anymore. That's used to happen back in 2012. The last sort of cases where elderly parents qualified for indefinite leave under that would have been around 2017, 2018. So I don't think you fall into that category where a sponsorship undertaking has been given. You have indefinite leave to remain. I don't know how you managed to get it, but you have indefinite leave to remain. You would be eligible for benefits in the same way that others are eligible for benefits. You may not be eligible for a state pension if you haven't worked here, but there are other benefits such as universal credit, employment support allowance that you're eligible for. And there is, if you're unwell, potentially attendance allowance that you're eligible for. So what do? You shouldn't just simply leave this and not deal with it. That's not the right approach. You're clearly looking at how you can be supported financially. You need to take that step. You need to speak to somebody who knows about the benefit system here. If not, speak to the professionals in this area, which is that you need to speak to the Citizens Advice Bureau. And whenever I have in practice referred clients on, they've managed to do that. Now, we've got some other follow-up questions coming in relation to that. Now, if the situation is that the lady does not have indefinite leave to remain and it's simply an extension, okay, an extension, fine. You can't apply for benefits straight away in that situation. But what you can do is ask for the no recourse to public funds condition on your visa to be lifted. The Home Office is granting the removal of no recourse to public funds application. They're granting those applications. So currently, your card will say you can't have access to public funds. You need to apply to get that lifted. So you need to speak to a lawyer really to do that. There's a simple change of conditions application which you make. The Home Office takes about a month. You need to explain your circumstances. They'll look at your last 6 months bank statements. They'll look at all your income. They'll want to know where the money's coming from, what your outgoings are, who's been supporting you, why they can't support you now. But they will, in the current climate, remove that condition which says you can't access public funds. You need to do that because if you do become eligible for public funds, potentially, if you could get certain benefits, you could get help with housing benefit, that could that could mean that your life is much easier. You need to, if need be, speak to a lawyer about this. There is a way of doing this. Thank you for that. We'll be taking a short break. Inshallah, we'll be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on it, you can ring on the landline number. And to send me a message, you can do so on the mobile number that appears at the bottom of the screen. Okay, let's look at the next question that's come in on WhatsApp. Again, very topical with the current pandemic that we have and the difficulties that people are facing because of that, related to that really. So our viewer says, if my wife didn't pass her B2 test in English, I think it might be B1 test in English, but the point is that if my wife didn't manage to pass her English test, what are the options as we have to apply for her visa in the next few months? As you know, COVID-19 locked all colleges and online was not so good. So, wife hasn't passed her test. What are the options? We would apply for an extension of her visa in the next few months. And because of COVID-19, colleges were closed. Online wasn't great. Now, the Home Office accepts that there has been some difficulties. And in my experience, what's happening at the moment is where people are unable to pass the test, whether it's the A2 test at the extension or the B1 test at the indefinite leave stage, A2 or B1, whichever one it is. If there's been a difficulty in passing the test, then in my experience, what the Home Office will do is to grant an extension of the visa. So you can rely on your previous English test certificate and apply for an extension. So if, and it's not clear, if you are thinking of applying for indefinite leave to remain at this stage, and the difficulty is you haven't got the English test, don't apply for indefinite leave to remain, apply for an extension. So if your wife's completed 5 years here, she qualifies for indefinite leave to remain, but because she hasn't passed her English test, she doesn't qualify at this stage, don't apply for indefinite leave to remain. Satisfy all the other requirements, except for the English requirement. Use your old certificate and simply get the extension. Then, once you've got the extension and your wife manages to hopefully go to college, do the course that needs to be done, gets her English up to the required standard. Once she passes the required English test, you don't have to wait until the extended visa comes to an end. As soon as she meets the English requirement, she can apply for indefinite leave to remain. So all's not lost. There is a way around it. Don't apply for indefinite leave. Get your extension, get the test done in the coming months, coming year, and then apply for indefinite leave to remain. Hope that answers your question. That brings us to the end of the show. Inshallah, we'll be back next week on Tuesday at 4 o'clock. See you then.